Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
Trademark offices like the USPTO in the US, the EUIPO in Europe, or the DPMA in Germany are the gatekeepers of brand protection. Their role is to register trademarks and, in some jurisdictions, check for conflicts. But they don't police the marketplace. That responsibility always falls on the brand owner. And when conflicts arise, two critical tools come into play: opposition and cancellation proceedings. Let's start with opposition proceedings. These are preemptive actions taken before a trademark is officially registered. When a new application is published, there's a short opposition window: 30 days in the US, 2 months in the EU, 3 months in Germany. During this time, third parties with earlier rights can step in and object. The grounds for opposition are well established: likelihood of confusion, lack of distinctiveness, descriptiveness, or even bad faith. The process usually begins with a cooling-off period where parties can negotiate. If no settlement is reached, both sides submit evidence and the office makes a decision. This might result in refusal, partial deletion of goods and services, or full registration. And of course, decisions can be appealed. The advantage: opposition is faster, less costly, and less disruptive than litigation. Now to cancellation proceedings. These happen after a mark is already registered. They come in two forms: invalidity and revocation. Invalidity challenges the trademark from the start. For example, if it should never have been registered because it was generic, descriptive, or conflicted with earlier rights. Revocation focuses on what happens after registration. If the mark hasn't been used for 5 years, has become generic, or is misleading in the marketplace. In both cases, the goal is the same: to remove the mark from the register, either retroactively or from the date of revocation. These proceedings can be initiated by any interested party and are generally handled by trademark offices, though courts can be involved as well. Burdens of proof vary. In non-use cases, it's usually the owner who must prove genuine use. And like oppositions, cancellations can also be appealed. So why does this matter for businesses? Because failing to monitor and act early can be costly. Oppositions and cancellations are far cheaper than litigation, and they prevent long-term problems like dilution, genericide, or expensive rebranding. Today, technology makes this work scalable. AI-powered monitoring tools scan trademark registers, social media, and e-commerce sites worldwide, flagging not only identical marks but also look-alikes and sound-alikes. They prioritize risks, collect evidence, and even generate draft takedown notices. But AI alone isn't enough. Legal counsel is critical for strategy, negotiation, and compliance across jurisdictions. The takeaway? Opposition and cancellation are essential levers in brand management. They keep registers clean, protect distinctiveness, and give businesses the tools to act before conflicts escalate. But the responsibility rests on the trademark owner. Proactive monitoring, backed by technology and expert legal guidance, is what transforms brand protection from a reactive necessity into a real competitive advantage.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.